Common questions about Labor Ministry's new rules. Here are key answers about the comprehensive work safety regulations. In November 2020, the Labor Ministry announced draft rules that will replace existing worker safety regulations across multiple sectors as part of implementing the 2020 Occupational Safety, Health and Working Conditions Code. This represents one of the most significant modernizations of India's labor framework in decades. What is this notification about? The Labor Ministry released comprehensive draft rules on November 19, 2020, establishing new standards for workplace safety, health protocols, and working conditions across India's diverse industries. What will these new rules do? These rules will consolidate and replace numerous sector-specific safety regulations into a single unified framework, making them more accessible, consistent, and easier to implement across all industries. Why are they making these changes? The government aims to enhance worker protection by modernizing outdated regulations, simplifying compliance for employers, and creating stronger safeguards that address India's evolving employment landscape under the 2020 Code. Who will these rules affect? The regulations will impact approximately 50 crore workers across organized and unorganized sectors, including those in construction, manufacturing, mining, contract labor, interstate migrants, and specialized professions like journalism and film production. When were these draft rules announced? The ministry published these draft rules on November 19, 2020, initiating a 45-day public consultation period for stakeholders to submit feedback before finalization. How will these rules be implemented? Implementation will occur in phases following the consultation period and final approval, with employers receiving appropriate transition periods to align their practices with the new regulatory requirements. What are the key benefits expected? The unified framework aims to enhance workplace safety standards, reduce industrial accidents, streamline compliance procedures, and foster a transparent regulatory environment that balances robust worker protection with business-friendly practices. Common questions about rules being replaced. The government is replacing multiple sector-specific worker safety rules with a single unified framework under the 2020 Occupational Safety, Health and Working Conditions Code. Here are answers to questions you might have about the rules being consolidated. Which worker safety rules will be replaced? The dock workers' safety rules, building and construction workers' rules, factory safety rules, and mining safety regulations will all be consolidated. These include detailed safety standards, inspection protocols, and compliance requirements that were previously administered under separate regulatory frameworks. Will rules for special worker groups change? Yes. Regulations for contract workers, interstate migrant workers, journalists, and audiovisual production workers will be integrated into the unified code. The new framework aims to provide more consistent protections while addressing industry-specific risks and working conditions. Why are these rules being replaced? These regulations are being consolidated to create a streamlined, comprehensive framework under the 2020 Occupational Safety Code. This unification eliminates contradictions between different regulations, reduces compliance burden for employers, and establishes consistent safety standards across all sectors. What will happen to the old rules? The existing regulations will be phased out once the new unified rules are formally approved and notified. A structured transition period will allow employers and workers to adapt to the new requirements before full enforcement commences. How many separate regulations are being consolidated? The new code will replace 13 separate labor laws related to workplace safety, occupational health, and working conditions that were enacted across different time periods. This represents one of the most significant regulatory streamlining efforts in India's labor legislation history. When will these changes take effect? Implementation will begin after the final rules are approved following the 45-day public consultation period. The ministry has established a phased implementation timeline, including comprehensive training for labor inspectors and educational programs for industry stakeholders. How will workers benefit from these changes? Workers will benefit from uniformly applied safety standards, more transparent violation reporting mechanisms, and strengthened enforcement procedures. The unified code extends protections to previously under-regulated work environments and simplifies the process for workers to understand their rights and entitlements. Questions about submitting your feedback. This section outlines the 45-day consultation period for submitting suggestions on the proposed rules, including submission methods, required information, and eligibility criteria. Your participation is essential in developing regulations that effectively serve both workers and businesses throughout India. We invite your input on the proposed occupational safety rules. Here's what you need to know about the consultation process. What is the time frame for submitting feedback? You have a 45-day window to submit feedback following publication of this notice in the official Gazette. This fixed timeline ensures adequate opportunity for stakeholders to review the proposed rules and develop comprehensive responses. As this period cannot be extended, please plan accordingly to ensure your input is considered. What are the submission methods? You may submit your feedback to Shri Shivakant Kumar via mail or email. Postal submissions should be addressed to Room Number 17, Shram Shakti Bhawan, Rafi Mark, New Delhi 110001. Electronic submissions should be sent to fastly@dgfastly.nic.in or shivkantkr@gov.in. Email is recommended for faster processing and confirmation of receipt. Please include feedback on OSH rules in your subject line. What information should I include? Your submission should contain 4 key components. 1. Your full name and complete contact details, including telephone number if available. 2. Specific reference to the rule or section you wish to address, with reference numbers where applicable. 3. Precise wording of your proposed amendment or new rule. And 4. A substantive rationale explaining how your suggestion would enhance worker safety or streamline compliance. Supporting evidence or comparative examples are highly valued in strengthening your proposal. Who is eligible to participate? The consultation is open to all stakeholders: individuals, workers, employers, trade unions, industry associations, safety professionals, NGOs, and other organizations. We value diverse perspectives and welcome input from all parties affected by these regulations. Your practical experience and expertise, regardless of formal qualifications, provide valuable insights for developing more effective safety standards. What is the review process for submissions? All feedback will be systematically evaluated by a dedicated committee comprising safety experts and government officials. While individual responses to submissions are not feasible, all input will be thoroughly considered before finalizing the rules. A summary of key themes from public consultation may be published alongside the final rules in the official Gazette. Your engagement in this consultative process is crucial for developing safety regulations that are practical, effective, and responsive to workplace realities across India. FAQs about new safety rules. These nationwide safety regulations establish comprehensive standards for working conditions, define essential terminology, and reference the Occupational Safety Code of 2020 for complete guidance. They provide thorough guidelines for both employers and employees to ensure workplace safety compliance across all industrial sectors. What are these rules called and where do they apply? These regulations are officially titled the Occupational Safety, Health and Working Conditions Central Rules 2020. They have nationwide jurisdiction across all of India and take effect upon publication in the official Gazette. These comprehensive rules govern all establishments employing 10 or more workers, ensuring uniform safety standards throughout the country. What important terminology should I understand regarding these rules? Code refers to the foundational legislation, the Occupational Safety, Health and Working Conditions Code 2020. Form denotes the official documents accompanying these rules. Registering officer designates the government-appointed official responsible for processing registrations. Establishment encompasses any location where industry, trade, business, or occupational activities are conducted. Employer identifies the individual with ultimate authority over the establishment's operations. What if I encounter undefined terms in the rules? When encountering terms used but not explicitly defined within the rules, consult the main code for clarification. If definitions exist in the code, those interpretations take precedence. The code functions as the authoritative reference document for understanding terminology and implementing the regulations correctly in your workplace. Who bears responsibility for implementing these rules? Employers hold primary responsibility for implementing these regulations within their establishments. Their obligations include ensuring adequate working conditions, providing appropriate safety equipment, conducting regular safety inspections, maintaining comprehensive records, and reporting incidents as mandated. Government-appointed safety officers will perform periodic compliance inspections. What are the consequences of non-compliance? Failure to comply with these regulations may result in penalties as specified in the code. These consequences range from substantial monetary fines to suspension of business operations, or in cases of willful violations resulting in accidents or fatalities, potential imprisonment. Regular mandatory safety audits will be conducted to verify compliance. How do these rules protect workers? These regulations establish essential standards for workplace safety, working hours, leave entitlements, and welfare facilities. They safeguard workers from hazardous conditions, ensure appropriate compensation for work-related injuries, and establish formal mechanisms for addressing grievances. Importantly, workers retain the right to refuse unsafe work without fear of retribution. Common questions about registration. Registration requires online form submission through the Shram Suvidha portal, electronic verification, and certificate issuance within 7 days. Your certificate must be prominently displayed at your workplace and cannot be transferred. All applications are processed digitally to ensure compliance with the Occupational Safety Code of 2020. How do I apply for registration? Complete Form I on the Shram Suvidha portal. Submit required documentation including business ownership proof, identity verification, and workplace safety compliance certificates. The intuitive online system guides you through each step of the submission process with clear instructions for all required fields. How is my application verified? Your PAN number or other identification is validated through an automated electronic verification system. This system cross-references your information with government databases to confirm legitimacy. If discrepancies arise during verification, you may be prompted to provide supplementary documentation. When will I receive my certificate? You'll receive Form 2, your official registration certificate, within 7 days of submission. If processing exceeds this time frame, your business is automatically considered registered under the Deemed Provision Clause. Application status can be tracked at any time through your Shram Suvidha portal account. What are the requirements for displaying my certificate? The certificate is non-transferable between entities or individuals. It must be prominently displayed at your workplace in an area accessible to both employees and inspecting authorities. You may use either a physical printed copy or a digital display, provided it remains clearly legible and easily visible. How long does my registration remain valid? Your registration certificate maintains indefinite validity unless officially canceled or suspended. However, you must update your registration details promptly whenever significant changes occur to your business structure, location, or operational scope. Is registration renewal required? Unlike many business permits, certificates under this code don't require periodic renewal. Instead, you're responsible for maintaining current information by promptly updating any business changes and fulfilling all mandatory reporting requirements as scheduled. Common questions about registration updates and cancellation. Business owners must update registration details within 30 days of any changes. Cancellation requires completing all reporting obligations and settling outstanding dues. The registration officer maintains comprehensive electronic records of all registered businesses. How do I update my registration details? When changes occur to your business ownership, structure, or contact information, you must update your profile on the Shram Suvidha portal within 30 days. This includes changes to your business name, ownership transfer, location, workforce size, or nature of work. Neglecting these updates may result in penalties or compliance issues during inspections. How can I cancel my registration? To close your business registration, submit an online cancellation request through the Shram Suvidha portal. Your application must include details about any outstanding payments due to workers, government agencies, or other stakeholders. You'll need to provide documentation confirming your business closure and proof that all worker entitlements have been settled. The registration authority will review your application before granting final approval. What do I need to do before canceling? Prior to cancellation approval, you must submit all required compliance reports for current and previous periods, clear all outstanding dues, including pending fees or penalties, and provide self-certification that you've fulfilled all obligations. You'll need to verify that all employee benefits have been properly settled, including Provident Fund contributions, gratuity payments, and other statutory benefits. The registration officer may conduct verification to ensure all legal requirements are satisfied. Who keeps track of registrations? A designated registration officer maintains electronic records of all businesses with registration certificates in Form 3. This digital database includes complete registration histories, updates, amendments, and inspection records for each registered entity. The electronic system enables efficient compliance verification, facilitates information sharing between government departments, and streamlines the inspection process. You can access your own registration records through the portal using your login credentials. Starting and ending work, FAQs. Business owners must notify authorities within 30 days of starting or ending operations by submitting Form IV online. Additional documentation is required for specific industries. When must I notify officials about my business operations? You must inform the inspector within 30 days of commencing operations and within 30 days of ceasing business activities. This requirement applies to all registered entities regardless of size or industry sector. Failure to provide timely notification may result in financial penalties and complications with your business registration status. What is the procedure for submitting this notification? Complete Form IV online through the Shram Suvidha portal with your digital signature. Include precise dates of business commencement and/or cessation. Provide comprehensive details about your business location, operational activities, workforce size, and ownership information. Ensure all submitted information is accurate and complete to prevent processing delays. How is my submitted information shared among agencies? Your information is automatically shared with EPFO, Employees Provident Fund Organization, and ESIC, Employee State Insurance Corporation. This integrated data sharing system facilitates compliance with multiple labor laws through a single submission process. Other relevant government departments may access this information as authorized by applicable regulations. What additional documentation is required for specialized industries? For factories, mines, dock work, or construction projects, you must submit Form IV alongside industry-specific permits and safety compliance certifications. When closing operations, include documentation confirming full settlement of all worker entitlements, including severance benefits. Hazardous industries require additional environmental clearance certificates both when initiating and terminating operations. Are there exceptions to these notification requirements? Small-scale enterprises with fewer than 10 employees may qualify for modified reporting protocols, though registration and operational change notifications remain mandatory. Seasonal businesses must report each operational cycle commencement and conclusion, regardless of regularity. What are the consequences of missing the 30-day notification deadline? Late notifications typically incur financial penalties calculated on a daily basis from the deadline date. Persistent non-compliance may result in more severe sanctions, potentially including temporary or permanent suspension of business licenses. If extenuating circumstances prevented timely notification, submit a formal explanation letter alongside your late Form IV submission for consideration. Questions about the appeal process. Appeals must be filed within 30 days of receiving a decision. The process includes submission, review of case records, and a hearing, with final decisions provided within 30 days of the appeal filing. Understanding each step ensures your appeal receives proper consideration. How do I appeal if I disagree with the registration decision? If you disagree with the registering officer's decision, you may file an appeal online within 30 days of receiving the order. You must provide your registration details, the original decision date, and specific grounds for reconsideration. Include any relevant new information or evidence that wasn't available during the initial review. What happens after I submit my appeal? If your appeal form is complete and properly filled out, the appeal officer will accept it and enter it into the system. You'll receive a confirmation notice with your appeal reference number, the name of the assigned appeal officer, and an estimated timeline for review. If there are any issues with your submission, you'll be contacted within 7 working days with correction instructions. Will the officer review my case information? Yes. Upon accepting your appeal, the appeal officer will request all case records from the registering officer electronically. This includes your original application, supporting documents, interview notes, and the detailed rationale for the initial decision. The appeal officer will conduct a thorough review before scheduling your hearing. You may also request access to these records to prepare your appeal. How will I learn of the final decision? The appeal officer will schedule a hearing, which may be conducted in person, by telephone, or via video conference based on your location and preferences. During this hearing, you'll present your case and respond to questions. You'll receive the final decision online or by mail within 30 days of your appeal submission. The decision document will include detailed reasoning and next steps. If successful, it will also provide instructions for proceeding with your registration. Can I submit additional evidence during the appeal process? Yes, you may submit additional documents or evidence up to 7 days before your scheduled hearing. All new evidence must be relevant to your case and clearly labeled with your appeal reference number. For optimal consideration, submit all relevant evidence with your initial appeal to prevent processing delays. What if I need more time to prepare my appeal? If you require more than the standard 30 days for appeal preparation, you may request an extension before the original deadline expires. Your request should clearly explain why additional time is needed. Extensions are typically granted for legitimate reasons such as gathering documentation, consulting advisors, or personal emergencies. Extensions are usually limited to a maximum of 15 additional days. Common questions about employer duties. Employers must fulfill specific health monitoring and documentation obligations, including coordinating annual medical examinations for senior employees and furnishing comprehensive appointment letters that clearly outline employment terms and conditions. When must employers arrange health checkups? Employers are legally required to provide complimentary annual health assessments for employees aged 45 and above. These examinations must be conducted within the first 120 days of each calendar year. The organization bears full financial responsibility for these medical evaluations and must maintain comprehensive records of completion for compliance purposes. Who can conduct the health checkups? Only certified medical practitioners are authorized to perform these assessments using the standardized Form V. The physician must issue official health certificates to both the employer and the employee. These medical documents must be preserved for a minimum period of 5 years and must remain accessible for regulatory inspection upon request. What documentation must employers provide to new employees? Employers must issue a formal appointment letter to every employee. This official document must specify the employee's full name, position title, compensation details, and comprehensive job responsibilities. The appointment letter should be presented on the first day of employment and requires signatures from both parties to validate the employment agreement. What information must be displayed in the workplace? Organizations must prominently display critical workplace information including operational hours, wage structures, payment schedules, and applicable labor regulations throughout the facility. This essential information must be presented in the primary language understood by the majority of the workforce to ensure clear communication and compliance. What records must employers maintain? Organizations are obligated to preserve detailed employment documentation including attendance logs, compensation records, leave registers, and other essential personnel information for all employees. These critical records must be retained for a minimum of 3 years and must be readily available for examination by labor authorities during compliance inspections. What are employers' responsibilities regarding workplace safety? Employers must establish and maintain a secure working environment by supplying appropriate safety equipment, delivering comprehensive safety training, and implementing regular safety inspections. Additionally, they are legally required to report any workplace incidents to the designated regulatory authorities within 48 hours of occurrence. Common questions about appointment letters. Appointment letters must include personal details, name, address, company information, LIN, UAN ESIC, payment terms, and job responsibilities benefits. This legal document serves as proof of employment and outlines the terms of the employment relationship. What personal details should be in my appointment letter? Your appointment letter must include your name, father's name, Aadhaar number, and job title. It should also contain your permanent and current addresses, date of birth, blood group, if available, and employment start date. These details establish your identity and employment status with legal clarity. What company information should be included? The letter must contain the company's labor identification number (LIN) and your universal account number (UAN) or Employee State Insurance Corporation (ESIC) number. It should also include the company's registered name, workplace address, GST number, and your reporting manager's details. This information validates the employment relationship officially. What payment details should my letter mention? Your letter must clearly specify your wages, basic pay, allowances, housing benefits, if applicable, and career advancement opportunities. It should detail your payment frequency, monthly, weekly, payment method, bank transfer check, salary deductions, overtime compensation rates, and any performance incentives or bonuses you're eligible to receive. What benefits and job duties should be listed? The letter must outline Social Security benefits, FO and ESIC, health checkup provisions, and your job responsibilities. It should specify working hours, weekly off days, paid leave entitlements, probation period, if applicable, notice period requirements, confidentiality obligations, and any role-specific conditions. This comprehensive information ensures mutual clarity regarding expectations. How long should my appointment letter be valid? Your appointment letter should clearly state whether your employment is permanent or temporary. For temporary positions, it must specify the exact duration or end date. For permanent roles, it should outline termination conditions from both parties. Always verify that these validity terms align with your understanding of the employment agreement before proceeding. Is my signature required on the appointment letter? Yes, both you and your employer must sign the appointment letter to make it legally binding. Ensure you receive a copy with both signatures for your records. Only sign after thoroughly reading and understanding all terms. If any aspect is unclear, request clarification before signing to avoid future complications. Accident reporting FAQs. Workplace accidents require prompt reporting using Form 6. Reporting time frames vary based on severity. Immediate notification for fatalities, within 12 hours following a 48-hour work absence for injuries, and within 12 hours for dangerous occurrences regardless of whether injuries occurred. What should I do if a fatality occurs in a workplace accident? You must immediately notify your inspector, chief inspector, district officer, local police, and the deceased worker's family. Additionally, submit Form 6 through the online portal. Your report must include comprehensive details about the accident circumstances, including precise time, exact location, and statements from any witnesses. Be aware that failure to report a workplace fatality immediately may result in substantial legal penalties and regulatory action. When do I report non-fatal workplace injuries? If a worker experiences an injury resulting in incapacitation for 48 hours or more, you must submit Form 6 within 12 hours after the conclusion of this 48-hour period. Your report should detail the specific nature of the injury, all medical treatment administered, and potential contributing factors. Note that these reporting deadlines remain mandatory regardless of weekends, holidays, or other business closures. What is the procedure for reporting dangerous occurrences? Submit Form 6 to your designated inspector and district officer within 12 hours of the incident. This reporting requirement applies even when no injuries have resulted from the occurrence. Your documentation should comprehensively describe the incident, analyze potential causes, and outline preventative measures implemented to mitigate further risk. Maintain thorough records of all communications with regulatory authorities regarding the incident for at least 5 years. Which form is required for all types of workplace incident reports? Form 6 serves as the standardized reporting document for all workplace accidents, injuries, and dangerous occurrences. This universal form ensures consistent information collection across all incident types. Every field must be completed accurately and comprehensively, with no sections left incomplete. Always retain duplicate copies of all submitted documentation for your organizational records and potential future reference. Who bears legal responsibility for filing workplace accident reports? The employer or designated facility manager holds legal accountability for ensuring timely and accurate accident reporting. This crucial compliance responsibility cannot be delegated to subordinate staff members. The reporting obligation applies equally to incidents involving both contract workers and permanent employees. Non-compliance with reporting requirements may result in significant legal consequences, including substantial financial penalties and potential criminal liability. What specific information must be documented in Form 6? Form 6 requires comprehensive documentation including precise date, exact time, specific location, complete details of injured individuals, detailed description of injuries sustained, thorough account of accident circumstances, identification of all witnesses, and documentation of subsequent remedial actions. Relevant medical reports and assessments should be attached as supporting documentation when available. Be advised that deliberately providing inaccurate or misleading information on Form 6 constitutes a serious regulatory violation subject to stringent penalties. Common questions about dangerous occurrences. Dangerous occurrences include pressure vessel explosions, equipment failures, structural collapses, and machinery falls. All must be reported to authorities within 12 hours, even if no injuries occur. These events pose significant risks to workplace safety and require immediate attention to prevent future accidents. What are pressure-related dangerous occurrences? These occur when pressurized vessels or pipes burst, including containers with petroleum, steam, or compressed air that explode. Such incidents can cause catastrophic facility damage and severe worker injuries. Regular inspection and maintenance of pressure vessels is essential for prevention. What equipment failures must be reported? Report all breakdowns of cranes, hoists, or lifting machines. Also report broken ropes or chains and crane tip-overs. These failures are particularly hazardous in construction and manufacturing environments. Each incident requires thorough investigation to identify root causes and implement preventive measures. What structural dangers need reporting? Report any collapse of building components such as walls, roofs, bridges, or tunnels. Also report fires, harmful gas leaks, and hazardous chemical spills. Structural failures can cause multiple casualties and extensive damage. Regular inspections by qualified engineers are crucial, especially for aging facilities or after extreme weather events. Do falls of machinery count as dangerous occurrences? Yes. Report any excavation machines, loading equipment, or transport vehicles that fall from height. These incidents often indicate inadequate site planning, improper operation, or unstable ground conditions. Even unoccupied machine falls must be documented and reported within the required time frame. Who needs to know about these dangerous occurrences? Notify both the inspector cum facilitator and district magistrate within 12 hours, regardless of injuries. Include details about location, time, nature of the event, and immediate actions taken. Failure to report within the specified time frame may result in penalties or regulatory action. What documentation should accompany dangerous occurrence reports? Include incident site photographs, witness statements, maintenance records of involved equipment, and details of any similar previous occurrences. This documentation facilitates thorough investigations and helps identify preventative patterns. Maintain copies of all reports and supporting documents for at least 5 years. What preventive measures should follow a dangerous occurrence? After reporting, conduct a comprehensive root cause analysis and implement appropriate corrective actions. These may include equipment repairs or replacements, additional safety training, revised procedures, or enhanced maintenance schedules. Document all preventive measures and perform follow-up assessments to verify their effectiveness. Common questions about work illness reporting. Employers and medical professionals must report occupational diseases listed in the third schedule. These reports require comprehensive information about the workplace environment and the affected worker to ensure proper tracking and prevention of workplace illnesses. What must employers do if a worker gets sick? If an employee develops a disease listed in the third schedule, the employer must immediately notify the inspector. This report must be submitted through the designated online reporting system to ensure timely processing and appropriate follow-up. What must doctors do if they see a sick worker? Medical professionals who diagnose or treat an employee with a third schedule disease must submit a detailed report to the Office of the Chief Inspector. This reporting requirement applies to all physicians treating workers from covered establishments. What information goes in these reports? Comprehensive reports must include establishment name and type, mineral extraction details for mining operations, patient information, full name, employee identification number, residential address, job position, specific diagnosis, date of diagnosis, and the attending physician's complete credentials and contact information. What diseases are on the third schedule list? The third schedule encompasses occupational diseases including silicosis, asbestosis, lead poisoning, noise-induced hearing loss, chemical-related skin conditions, respiratory illnesses from industrial dust exposure, and diseases resulting from exposure to biological agents, radiation, or extreme temperature conditions. How soon must these reports be filed? Employers are required to submit reports within 24 hours of becoming aware of an occupational illness. Medical practitioners must complete and transmit their diagnostic reports within 7 days of confirming a third schedule occupational disease in a worker. What happens if someone doesn't report a work illness? Non-compliance with occupational disease reporting requirements constitutes a serious violation of workplace safety regulations. Both employers and healthcare providers who fail to report can face significant financial penalties and potential administrative sanctions under applicable occupational health and safety legislation. Employee duties and rights, frequently asked questions. Workers must report safety concerns, while employers must address them promptly and document all reports regardless of perceived validity. Understanding these mutual responsibilities is essential for maintaining a safe workplace environment. What should I do if I see something unsafe at work? You must inform your supervisor, safety officer, or manager immediately. This can be done via telephone, written communication, or through online reporting systems. Prompt reporting helps prevent accidents and safeguards all personnel within the workplace. What happens after I report a safety problem? Your employer must immediately address any hazard that poses potential harm. They should take prompt action to eliminate the danger and secure the area. Additionally, they are required to inform you about the remedial measures taken and provide a timeline for complete resolution. Does my boss need to tell anyone about the safety problem? Yes. Your employer must submit a formal report to the inspector detailing the remedial actions taken, regardless of whether they consider the concern valid. This report must include comprehensive information about the issue, the resolution approach, and preventative measures implemented. How can I report a safety problem? You may report concerns via telephone, written communication, or online platforms, for whichever method is most accessible. Many organizations have designated reporting forms or digital systems for documenting safety concerns. Consult your supervisor or reference your employee handbook for the appropriate reporting protocol at your specific workplace. What is my main duty as a worker? Your primary responsibility is to alert management about potential hazards that could endanger yourself or colleagues. Additionally, you must adhere to established safety protocols, utilize appropriate protective equipment, and actively participate in safety training programs. Remember that workplace safety requires universal participation. Can I be punished for reporting a safety problem? No. Legislation prohibits employers from retaliating against employees who report safety concerns. Protected activities include reporting, and you cannot legally be terminated, demoted, have hours reduced, or face any adverse treatment as a consequence. If you experience retaliation, contact the safety inspector immediately. What if my boss doesn't fix the safety problem? If your employer fails to address a significant safety concern, you should escalate the matter to the safety inspector. In situations involving immediate danger, you may be entitled to refuse hazardous work until the issue is resolved. Maintain thorough documentation of all communications regarding the safety concern and preserve records of when you initially reported it. FAQs about Safety and Health Board. The Safety and Health Board operates under central government oversight, convenes as necessary, and follows specific protocols for membership, resignation, and attendance. Members serve defined terms and must adhere to established governance procedures. Who appoints board members? The central government selects and approves members specified in Section 16, 2G, J, K, L, M, and N. Appointments are based on workplace safety expertise, industry knowledge, and dedication to health standards. What is the board's meeting frequency? The board convenes as frequently as required to fulfill its responsibilities outlined in Section 16(1). This typically involves monthly regular sessions with additional emergency meetings when urgent safety issues arise. What is the resignation process for members? Members may resign by submitting a written notice to the chairperson. Resignations become effective upon acceptance or after 30 days, whichever occurs first. When possible, members should provide 14 days notice to maintain operational continuity. What constitutes membership termination? Members who miss 3 consecutive meetings without the chairperson's authorization lose their membership automatically. Exceptions may be granted if the central government determines sufficient justification existed for the absences. The board secretary maintains official attendance records. What are the terms of service for board members? Members typically serve 3-year terms. The central government may reappoint individuals for additional terms, though no member may serve more than 2 consecutive terms without a 1-year interim period. What constitutes a quorum for board meetings? Valid meetings require attendance by at least half of all board members. Decisions are made by simple majority vote of attending members, with the chairperson casting the deciding vote in tied situations. Are board members eligible for compensation? Yes. Members receive sitting fees for meeting attendance and reimbursement for reasonable travel and accommodation expenses incurred during official board duties, according to rates established by the central government. FAQs about board membership rules. Board membership eligibility is restricted based on mental health capacity, financial solvency, and criminal history. The central government maintains authority to remove members, particularly those no longer effectively representing their constituencies, but must provide an opportunity for defense before any removal action. Understanding these regulations ensures proper governance and effective representation. Who cannot be a board member? You cannot serve as a board member if a qualified medical professional has determined you have mental health conditions that impair your decision-making capacity, you are financially insolvent, unable to meet your debt obligations, or have been legally declared bankrupt. You have served a prison sentence of 3 months or longer for any offense involving moral turpitude. You have been convicted of any offense related to workplace safety violations. Can the government remove a board member? Yes. The central government may remove a member they determine no longer adequately represents their designated constituency. This includes instances where a member has changed their professional affiliation or ceased active involvement in the sector they were appointed to represent. The government maintains this authority to ensure the board composition appropriately reflects all key stakeholders. Do members get a chance to explain before being removed? Yes. Before removal, the government must provide the member an opportunity to present their case, either verbally or in writing. This adheres to fundamental principles of natural justice. The member will receive formal written notification of the removal consideration and will have a minimum of 14 days to prepare and submit their defense, either through written documentation or by requesting a personal hearing with the appropriate authority. Who decides if a member should leave the board? The central government makes the final determination. The decision rests with the ministry overseeing the board, typically acting upon the chairperson's recommendation. In cases of dispute, the central government's decision is deemed final and binding on all parties involved. What happens to ongoing work when a member leaves? When a member departs, the chairperson will reassign any committee responsibilities or special projects previously under that member's leadership. The board maintains operational continuity through comprehensive documentation of all ongoing initiatives. Newly appointed members filling vacancies receive thorough briefings on relevant matters to ensure seamless transitions without disruption to the board's essential functions. Common questions about allowances and reports. This guide addresses travel reimbursement policies for both official and non-official members, along with critical requirements for employer safety reporting through the mandatory online system. Questions about travel reimbursement. How do official members get reimbursed for travel? They follow their standard work travel policies. The office that processes their regular salary will handle these reimbursements, covering transportation, daily allowances, and accommodation expenses according to their entitlement level. What about non-official members? They receive compensation according to guidelines established by the Department of Expenditure, Ministry of Finance, which typically includes standardized daily allowances and reimbursement for documented travel expenses. Is advance payment available? Yes, members may request advance payment for anticipated travel expenses by submitting the required form at least 7 days before departure. How should members submit expense claims? All members must submit completed travel expense forms with original receipts within 30 days of completing their journey. Questions about safety reporting requirements. How do employers submit safety reports? All safety information must be submitted through the designated online portal. As of January 2023, paper submissions are no longer accepted. What information must be reported? Employers must document workplace accidents, injuries, work-related illnesses, near-miss incidents, hazardous conditions identified, and corrective actions implemented. Why is this reporting mandatory? This data collection enables authorities to monitor workplace safety trends, identify emerging hazards, develop targeted safety standards, and provide specialized guidance to high-risk sectors. How frequently must reports be submitted? Routine safety reports are required quarterly, while serious incidents must be reported within 24 hours of occurrence. What are the consequences of non-compliance? Failure to submit required reports may result in penalties as outlined in Section 85 of the Act, including substantial fines and additional administrative sanctions. Safety Committee FAQs. Safety committees are required for workplaces with 500-plus workers, must include both management and worker representatives, and meet quarterly or monthly for mines. When do we need a safety committee? A safety committee is mandatory for workplaces with 500 or more workers, as specified in the Factor E Act for all industrial establishments. Smaller workplaces are also encouraged to establish safety committees as they significantly contribute to improving workplace safety standards and practices. Who should be in the safety committee? The committee must include representatives from both management and workers to ensure balanced perspectives. Female workers should be included to ensure diverse representation and address gender-specific safety concerns. Equal representation between management and workers is essential to maintain fairness and effectiveness in decision-making processes. How often should the safety committee meet? Regular meetings must be held at least once every 3 months for most workplaces. For mining operations, more frequent meetings are required for at least once every month due to higher safety risks. Additional special meetings can be convened in case of emergencies, serious accidents, or when urgent safety concerns require immediate attention. How are worker members chosen? In workplaces with unions, the worker representatives are nominated by the recognized trade union. Where no union exists, workers select their representatives through a transparent democratic election process. Selected members should represent various departments and work areas to ensure comprehensive safety oversight across the entire facility. What information can the Safety Committee access? The committee has the right to access comprehensive information about workplace safety risks, incident reports, and safety inspection results. They should be provided with all relevant safety data, inspection documentation, and accident investigation findings to develop informed safety recommendations. What are the committee's responsibilities? The Safety Committee is tasked with identifying potential hazards, investigating workplace incidents, recommending safety improvements, monitoring implementation of safety measures, and promoting safety awareness through comprehensive training and education programs for all workers. How long do members serve? Committee members typically serve for a defined term of 2-3 years to balance continuity with fresh perspectives. This tenure structure allows for building expertise while periodically introducing new ideas and approaches. Members may be eligible for reappointment or re-election for additional terms according to established workplace policies. How should meetings be documented? All Safety Committee proceedings must be thoroughly documented with comprehensive meeting minutes. Documentation should include attendance records, detailed discussion points, specific recommendations, assigned action items, and implementation deadlines. These records must be properly maintained and made available for review during regulatory inspections or audits. Safety Committee, Common Questions. Safety committees are led by senior management and include representatives from various departments. Their primary role is to identify hazards, improve workplace safety, and provide safety training to workers. Who leads the Safety Committee? A senior manager serves as the committee chairman. This individual is responsible for establishing meeting agendas, facilitating productive discussions, and ensuring follow-through on action items. The safety officer functions as committee secretary, documenting minutes and maintaining all official committee records. Who else serves on the Safety Committee? The committee includes representatives from production, maintenance, and procurement departments to ensure comprehensive workplace coverage. Members from different shifts participate to address safety concerns across all operational hours. If available on-site, a medical professional joins to provide healthcare expertise on occupational health issues and preventive measures. What does the Safety Committee do? The committee enhances workplace safety through systematic facility and equipment inspections. They analyze safety reports to develop targeted corrective action plans. Additionally, they review accident investigations to determine root causes and implement preventive measures to prevent recurrence.
How does the committee help workers? They educate employees through regular toolbox talks and equipment safety demonstrations. The committee conducts training on emergency protocols and first aid procedures. Safety information is consistently communicated via bulletin boards, digital platforms, and regular safety meetings to maintain high safety awareness throughout the organization. How does the committee improve safety? They proactively identify potential hazards through comprehensive risk assessments and pre-task safety analyses. The committee recommends safety improvements through engineering controls, administrative procedures, and appropriate personal protective equipment. Effectiveness is measured by tracking safety metrics, analyzing incident trends, and gathering worker feedback on safety initiatives. Common questions about Mine Safety Committee. The Mine Safety Committee comprises leadership from management, 5 democratically elected worker representatives including contractors, members with specialized technical expertise, and a medical doctor, all collaborating to ensure mine safety and foster a healthier working environment for everyone on site. Who leads the Mine Safety Committee? The mine manager serves as committee chairman with final decision-making authority. The manager appoints 5 additional mine officials to the committee, typically selecting supervisors from diverse operational areas to ensure comprehensive oversight across all mining activities. How many workers are on the committee? 5 worker representatives serve on the committee, advocating for the interests of the general workforce. This includes contractor-employed workers to ensure all perspectives are represented. These representatives are democratically elected through a voting process open to all mine employees. including contract workers. Are there members with special skills on the committee? Yes. The committee strategically includes individuals with specialized expertise in critical areas such as underground mining operations, electrical systems, and mechanical equipment maintenance. A dedicated safety officer serves as committee secretary, maintaining comprehensive records of meetings, decisions, and safety recommendations. Is there a doctor on the committee? Yes. A qualified medical doctor from the mine site serves as an essential committee member. The doctor provides expert medical guidance when evaluating safety protocols, reviews health-related incidents, and advises on occupational health matters affecting miners' well-being. How often does the Mine Safety Committee meet? The committee conducts regular monthly meetings to address ongoing safety concerns. Additionally, special emergency sessions are convened immediately following any accidents or when significant safety hazards requiring urgent attention are identified. What authority does the Mine Safety Committee have? The committee is empowered to inspect any area of mine operations, review safety procedures, recommend improvements to management, and in cases of imminent danger, can recommend temporary work stoppages until hazardous conditions are properly remediated. Common questions about Mine Safety Committee. The Mine Safety Committee proactively identifies hazards, reviews safety plans, investigates accidents, and develops educational programs to enhance mine safety. Their comprehensive approach integrates prevention, investigation, and education to ensure effective implementation of all safety protocols. What does the Mine Safety Committee do to improve safety? The committee conducts systematic inspections to identify hazardous conditions and develop targeted remediation plans. They assess potential dangers across all operational areas, prioritize issues through rigorous risk assessment, and ensure safety improvements are properly implemented and sustained over time. How does the committee help prevent accidents? They meticulously review safety protocols before commencing work in new areas or integrating new equipment. The committee scrutinizes operational procedures, conducts comprehensive risk assessments, evaluates equipment against established safety standards, and delivers actionable recommendations. This proactive approach mitigates potential hazards before they escalate into accidents. What happens after an accident? The committee launches a thorough investigation and scrutinizes all incident reports. They gather testimony from witnesses, examine environmental factors, analyze operational procedures, and identify fundamental causes. Their findings inform targeted recommendations to prevent recurrence, with ongoing monitoring to verify implementation effectiveness. How does the committee help workers learn about safety? They design specialized training programs informed by incident data and industry standards. The committee creates role-specific educational resources, conducts regular safety drills, implements clear emergency communication protocols, and facilitates company-wide safety knowledge sharing. They continuously evaluate program effectiveness and implement refinements to maximize impact. Common questions about safety officer jobs. Safety officer positions require specific qualifications, including relevant degrees combined with professional experience or specialized safety education. Multiple pathways exist for candidates with backgrounds in engineering, government regulatory work, or safety training. These qualifications ensure safety officers possess the comprehensive knowledge necessary to effectively implement and oversee workplace safety protocols. What education do I need to be a safety officer? Qualifying pathways include an engineering degree with 2+ years of work experience, a physics or chemistry degree with 5+ years of relevant experience, an engineering diploma with 5+ years of professional experience, or a specialized safety degree. Each option ensures you develop the technical expertise required to identify hazards and implement effective safety measures. Many employers also value supplementary certifications in occupational health and safety to enhance your formal qualifications. Can I qualify with government work experience? Yes. An engineering degree or diploma plus 5+ years working in a government office overseeing factories, buildings, or docks meets qualification requirements. This experience is particularly valuable as it typically involves regulatory compliance and inspection activities directly transferable to safety officer responsibilities. Government experience provides critical insights into legal requirements and enforcement procedures essential for comprehensive workplace safety management. I work in safety training. Can I apply? Yes. 5 years of full-time experience and safety training, education, consultancy, or accident prevention research qualifies you for safety officer positions. This background demonstrates your thorough understanding of safety protocols and ability to effectively communicate critical safety information. Safety trainers typically develop exceptional skills in hazard recognition, risk assessment, and practical application of safety principles for all highly valuable competencies for safety officer roles. Do I need specialized safety education? Not necessarily. An engineering degree with appropriate work experience is sufficient. However, a government-recognized safety degree or diploma also satisfies requirements. Specialized qualifications in occupational health and safety or industrial hygiene can provide a more direct qualification pathway. Many successful safety officers combine technical backgrounds with ongoing professional development through industry workshops, seminars, and certifications to remain current with evolving safety standards. What skills are important for a safety officer? Beyond formal qualifications, effective safety officers require strong analytical abilities for hazard identification, excellent communication skills for explaining safety procedures, and refined interpersonal capabilities for working across organizational levels. The role demands meticulous attention to detail during inspections, appropriate assertiveness when enforcing regulations, and creative problem solving when developing safety initiatives. Proficiency with documentation systems and the commitments to stay current with evolving regulations are increasingly essential in today's safety environment. Are there continuing education requirements? While initial qualifications secure employment, most organizations expect safety officers to engage in continuous professional development. This typically includes participating in industry conferences, completing specialized courses, obtaining advanced certifications, and engaging with professional safety associations. Maintaining current knowledge of regulatory changes, advanced hazard identification techniques, and emerging best practices is fundamental for long-term effectiveness. Most progressive employers actively support and often require structured continuing education programs. Common questions about safety officers and dock works. Safety officers monitor workplace conditions, identify potential hazards, implement comprehensive safety protocols, and evaluate their effectiveness to protect workers and dock environments. They play a critical role in maintaining compliance with regulatory standards and fostering a culture of safety awareness throughout dock operations. What does a safety officer do? A safety officer ensures workplace safety by advising management on hazard mitigation strategies and accident prevention measures. They develop comprehensive safety policies, conduct regular safety meetings, maintain detailed documentation, and coordinate with regulatory agencies to ensure compliance with local and international dock safety standards. Their proactive approach helps identify and address safety concerns before incidents occur. 1. How do safety officers assess job safety? They conduct thorough evaluations of work processes to identify potential hazards and implement safety improvements. This involves performing detailed risk assessments for each dock operation, analyzing equipment safety features, monitoring environmental conditions that might compromise worker safety, and reviewing incident reports from similar operations to proactively identify and address potential hazards before they cause harm. 2. How do safety officers evaluate safety protocol effectiveness? They measure the impact of implemented safety measures by tracking accident reduction rates and other key metrics. Safety officers monitor specific performance indicators including incident frequency rates, near-miss reports, and safety audit scores over time. They also collect worker feedback regarding safety measure effectiveness and conduct comparative analyses against industry benchmarks to objectively evaluate their safety programs' performance. 3. What occurs during safety inspections? Safety officers conduct thorough workplace walkthroughs to identify hazards, observe work practices, and provide recommendations for correcting unsafe conditions and behaviors. These inspections include verifying proper use of personal protective equipment, confirming machinery lockout-tagout procedure compliance, ensuring proper storage of hazardous materials, and checking that emergency response equipment remains accessible and functional. They document all findings, assign specific corrective actions with clear deadlines, and conduct follow-up inspections to verify completion. FAQs about safety officer duties. Safety officers are responsible for accident investigation, illness monitoring, safety promotion, and comprehensive worker training to maintain and enhance workplace safety standards across all operations. What do safety officers do about accidents? They manage the reporting and investigation of workplace incidents. They conduct thorough examinations of significant accidents to determine root causes and contributing factors. Safety officers methodically collect evidence, interview witnesses, and document detailed findings to prevent recurrence. They collaborate with management to develop and implement effective corrective actions based on investigation conclusions. How do safety officers monitor work-related illnesses? They systematically investigate occupational illnesses that require reporting according to regulatory codes. Safety officers analyze patterns of work-related diseases, monitor employee exposure to hazardous substances, and ensure affected workers receive appropriate medical care. They maintain comprehensive illness incident records and develop targeted prevention strategies to mitigate health risks in the workplace. How do safety officers promote safety awareness? They organize strategic safety campaigns, competitions, and initiatives to foster a culture of safety compliance among workers. Safety officers create engaging educational materials such as informative posters, regular newsletters, and digital resources to heighten awareness. They facilitate periodic safety meetings, recognize exemplary safety performance, and cultivate a proactive safety mindset throughout the organization. Do safety officers provide worker training? Yes. They design and implement comprehensive training programs to equip workers with accident prevention skills. They often coordinate with training departments to ensure consistent messaging. Safety officers develop role-specific safety instruction, conduct scheduled refresher sessions on critical procedures, and verify all personnel understand emergency protocols. They assess training effectiveness through systematic feedback collection and workplace observations to continuously refine safety education. FAQs about safety officers in mines. Mine safety officer requirements are determined by workforce size, with one officer required per 500 workers in mines employing 100 plus personnel. Qualification criteria vary by mine type. Coal mines require first-class manager's certificate holders, metal mines need appropriate manager's certificates, and oil mines demand engineering safety degree holders with 5-10 years of management experience. Below are frequently asked questions regarding safety officers in mining operations. How many safety officers does a mine need? Mines with 100 or more workers must employ one safety officer for every 500 workers. For instance, a mine with 800 workers requires 2 safety officers. Even mines with fewer than 100 workers may need a designated safety coordinator, depending on local regulations and site-specific hazards. Who can serve as a safety officer in underground coal mines? Qualified individuals must possess a first-class manager's certificate for coal mines. This certification verifies expertise in underground coal mining hazards, including methane gas management, roof support systems, and ventilation requirements. Who qualifies as a safety officer in open-cast coal mines? Eligible candidates must hold either a first-class manager's certificate for coal mines or a specialized certificate for open-cast operations. Surface mining presents unique challenges including slope stability, blast management, and heavy equipment safety protocols. What qualifications are needed for safety officers in metal mines? Individuals must possess the appropriate manager's certificate for metal mines. This credential demonstrates proficiency in addressing metal mining hazards such as rock bursts, ground support systems, and specialized ventilation requirements based on the metals being extracted. What are the requirements for oil mine safety officers? Candidates must hold an engineering or safety degree complemented by 5-10 years of managerial experience in oil mining operations. This extensive experience ensures familiarity with oil extraction challenges, including fire prevention, pressure management, and chemical safety protocols. What key responsibilities do mine safety officers hold? Safety officers conduct systematic inspections, develop comprehensive safety protocols, investigate incidents thoroughly, provide essential safety training, ensure regulatory compliance, monitor hazardous conditions continuously, and maintain detailed safety documentation. They serve as the primary liaison for worker safety concerns. What is the recommended inspection frequency for safety officers? Best practices include daily inspections of high-risk areas, weekly reviews of general work zones, and monthly comprehensive audits of the entire operation. Additional inspections are mandatory following incidents or when new equipment is installed. What training do safety officers require? Beyond baseline certifications, safety officers must complete specialized training in emergency response, advanced first aid, hazard identification techniques, risk assessment methodologies, accident investigation procedures, and relevant mining regulations. Many jurisdictions mandate annual refresher courses to maintain professional qualifications. Common questions about mine safety officers. Safety officers fulfill vital roles in monitoring mine conditions, conducting worker training, investigating incidents, and maintaining comprehensive safety records. Their expertise ensures regulatory compliance and protects workers through proactive risk management and continuous safety improvement initiatives. What do safety officers check during site inspections? They conduct thorough evaluations of all mine areas, engage with workers about safety concerns, and solicit improvement suggestions. They meticulously inspect equipment functionality, maintenance status, ventilation systems, structural supports, and evacuation routes to verify compliance with established safety standards. How do safety officers onboard new miners? They provide comprehensive site orientations, clearly distinguish between safe and hazardous practices, and ensure thorough understanding of mine safety protocols. They deliver practical training on safety equipment and emergency procedures, while pairing newcomers with experienced miners who provide mentorship on task-specific hazards. What is the safety officer's role following an incident? They investigate all incidents regardless of severity, conducting root cause analysis to prevent recurrence. Their process includes witness interviews, detailed site examinations, and documentation of findings. They develop comprehensive reports with preventative recommendations and update safety protocols to address any identified systemic vulnerabilities. How do safety officers perform incident analysis? They maintain detailed incident records and analyze this data to identify patterns and trends. Using specialized analytical software, they track incidents over time to prioritize safety interventions. They compile periodic reports for leadership that highlight high-risk areas and recommend evidence-based safety initiatives derived from statistical analysis. Common questions about mine safety officers. Mine safety officers identify potential hazards, provide comprehensive training, ensure regulatory compliance, and develop safety programs to protect the well-being of all mining personnel. What dangers do safety officers look for? They identify critical risks including flooding hazards, fire threats, coal dust accumulation, and gas buildup in oil mines. They promptly report these dangers to mine management. They systematically inspect for unstable ground conditions, malfunctioning equipment, obstructed emergency exits, and inadequate ventilation systems. Safety officers perform regular air quality monitoring to detect harmful gases before concentrations reach dangerous levels. They thoroughly examine support structures to prevent cave-ins and rockfalls that could potentially trap workers underground. How do safety officers teach workers about safety? They conduct comprehensive safety classes and deliver informative presentations to team leaders. They also organize dedicated safety weeks and specialized training events. Safety officers develop tailored training materials that address specific hazards present in different areas of the mining operation. They facilitate practical demonstrations of safety equipment usage and emergency response procedures. Monthly refresher courses ensure all personnel remain updated on current safety protocols and best practices. They maintain an accessible safety resource center where workers can obtain information about industry best practices and learn from documented incidents. Do safety officers check if rules are followed? Yes. They ensure all workers understand established regulations and safety protocols. They inform management when compliance issues are identified. Safety officers conduct unannounced inspections across all shifts to verify consistent adherence to safety standards. They review surveillance footage to identify unsafe behaviors that might otherwise go undetected during standard inspections. They implement recognition programs to acknowledge teams demonstrating exemplary safety performance. When violations occur, they collaborate with supervisors to develop effective corrective action plans rather than focusing solely on disciplinary measures. What training help do safety officers provide? They assist in developing comprehensive training for essential skills, gas detection procedures, firefighting techniques, and first aid protocols. They also demonstrate proper safety practices. Safety officers coordinate with equipment manufacturers to arrange specialized training on new machinery and technology. They design realistic emergency response simulations that prepare workers for various crisis scenarios. Training programs incorporate both theoretical instruction and practical field exercises to ensure workers can effectively apply their knowledge in actual situations. They train selected employees to serve as safety advocates who help monitor workplace conditions and mentor new workers within their teams. Common questions about work hours. Standard work regulations limit weekly hours to 48, daily hours to 12, and require regular rest breaks. Schedules may be flexible within these parameters to accommodate various work arrangements. How many hours can I work in a week? The maximum is 48 hours per week, including hours from all employment if you hold multiple jobs. Some industries have specific exemptions, or you may sign an opt-out agreement to work additional hours if desired. How long can my workday be? Your workday, including breaks, must not exceed 12 hours to ensure sufficient time for rest and personal activities. During exceptional circumstances, temporary extensions may be permitted, provided your health and safety remain protected. When do I get rest breaks? You're entitled to a minimum 30-minute uninterrupted break after working 5 consecutive hours. This break may be unpaid. For workers under 18, a 30-minute break is required after 4.5 hours. Additionally, you must receive 11 consecutive hours of rest between workdays. Can my work schedule change? Yes, provided the 48-hour weekly maximum isn't exceeded. Employers should give reasonable advance notice of schedule changes. Many workplaces offer flexible arrangements such as flexi-time, job sharing, or compressed work weeks to accommodate employee needs. Do these rules apply to all types of workers? Several professions operate under different regulations. Exemptions may apply to managing executives, family workers, religious officiants, emergency services personnel, and certain specialized roles. Transport workers and journalists follow industry-specific regulations designed for their unique working conditions. What about overtime work? Work beyond your contracted hours constitutes overtime and must still comply with the 48-hour weekly limit unless you've signed an opt-out agreement. Employers typically offer enhanced compensation rates or compensatory time off for overtime hours worked. Are there special rules for night workers? Workers who regularly perform at least 3 hours during nighttime, typically 11 p.m. to 6 a.m., are classified as night workers. These employees should not exceed an average of 8 working hours in any 24-hour period and are entitled to free regular health assessments to monitor the effects of night work. FAQs about special working hours. Special regulations govern transport workers and journalists with distinct rules for driving times, shift durations, and mandatory breaks. These industry-specific standards ensure worker well-being and service quality. How long can transport workers drive without a break? Transport workers must take a full 45-minute break, which can be split into one 15-minute and one 30-minute rest period, after 4.5 consecutive hours of driving. These mandatory intervals help prevent fatigue and ensure road safety. How many hours do journalists work? Journalists are limited to 6 hours per day shift and 5.5 hours per night shift. These restrictions acknowledge the mentally demanding nature of journalistic work and help maintain high-quality reporting while preventing exhaustion. When do journalists get rest breaks? Journalists receive mandatory 30-minute breaks after 4 hours of day shift work or 3 hours of night shift work. These breaks cannot be scheduled at the beginning or end of shifts. During emergency news coverage, breaks may be delayed but must still be provided. What happens if journalists work extra hours? Journalists who work beyond scheduled hours receive equivalent compensatory rest time within the following 7 days, in addition to regular weekly rest periods. Many organizations also provide overtime pay according to their compensation policies. Are there special rules for weekend work for journalists? Journalists working weekends receive either premium compensation, typically 150% of standard wages, or additional time off. They must also be scheduled for at least 2 consecutive weekend days off monthly, regardless of other work arrangements. What are the maximum weekly hours for transport workers? Transport workers are restricted to 56 working hours in any single week and must maintain an average of no more than 48 hours weekly over a 17-week period. These limits encompass all work-related activities including driving, loading, unloading, and administrative tasks. FAQs, working rules for journalists and sales staff, essential regulations governing night shift limitations, mandatory rest periods between shifts, annual holiday entitlements, and compensation policies for non-working days. How long can I work on night shifts? Night shift assignments are limited to a maximum of 1 consecutive week. Additionally, you cannot be scheduled for night shifts more than once within any 14-day period to ensure adequate recovery. How much rest time do I need between shifts? When transitioning between night and day shifts, you must have a minimum rest period of 24 hours. Transitions between similar shifts, day to day or night to night, require at least 12 hours of rest between assignments. How many holidays do I get each year? You are entitled to 10 paid holidays per calendar year. If operational requirements necessitate working on a designated holiday, you will receive a compensatory day off to be scheduled at a mutually agreed time. Do I get paid for holidays and rest days? Yes. Full compensation is provided for all designated holidays and weekly rest days, equivalent to your regular daily wage, regardless of whether you work on those days. What are the maximum daily working hours? Standard daily working hours for regular staff are capped at 8 hours. During special projects or exceptional circumstances, this limit may be extended to 10 hours with prior written management approval. How are overtime hours compensated? Overtime work on weekdays is compensated at 1.5 times your standard hourly rate. Weekend overtime carries a premium rate of 2 times your regular hourly compensation. What meal breaks am I entitled to? For shifts exceeding 6 hours in duration, you are entitled to a mandatory 1-hour meal break. While this break is unpaid, it is required by company policy to maintain employee well-being and productivity. Frequently asked questions about leave. Leave applications require written submission 1 month in advance except for emergencies, may be denied with written justification, and include holidays falling within the leave period. How do I apply for leave? Submit a written request to your manager. This applies to all employees for any leave type. Include your name, employee ID, department, requested dates, reason for leave, and contact information during your absence. Your supervisor will forward the request to HR for processing. When should I apply for leave? Submit applications 1 month before your intended leave begins. For sick leave or emergencies, apply as soon as circumstances allow. Advance notice helps ensure adequate coverage. Late applications without valid emergency justification may be rejected based on operational needs. Can my leave request be denied? Yes. If denied, your manager must provide a written explanation. Typical reasons include critical operational periods, overlapping staff absences, or insufficient notice. You may appeal through HR within 7 working days of receiving the denial notification. What about holidays during my leave? Holidays occurring during your leave period count as part of your leave. Extending leave by adding holidays before or after requires specific authorization. This prevents artificial leave extensions. Public holidays during leave are not counted separately or compensated unless specifically approved by management. Can I cancel or change my approved leave dates? Yes. by submitting a written modification request at least 14 days before your original start date. Late changes may be declined if coverage arrangements have been finalized. Emergency cancellations are evaluated individually based on circumstances. What happens if I exceed my approved leave period? Unauthorized extension of leave constitutes unauthorized absence, potentially resulting in disciplinary action and/or unpaid leave for the additional days. If facing unavoidable return delays, contact your supervisor immediately with supporting documentation. How is my leave balance calculated? Leave balances are determined by your employment contract, service duration, and applicable labor regulations. HR maintains these records, and you can request an updated leave balance statement anytime. Unused annual leave may be carried forward or compensated according to company policy. Leave and medical rules. Common questions. Companies may recall employees from approved leave periods when necessary and typically require medical certification after sick leave. Travel expenses for recalls are reimbursed according to established company policies. Understanding these regulations helps employees effectively manage their leave situations. Can my company recall me while I am on leave? Yes. Your company can request your return from leave due to urgent operational requirements or emergencies. If you are away from your workplace, the company will cover your travel expenses. This policy applies to all leave categories including annual, casual, and earned leave. How are travel reimbursements determined if I am recalled from leave? Travel reimbursements follow your company's standard business travel policies. This typically includes transportation costs, necessary accommodation, and applicable daily allowances. The same travel expense guidelines that govern business trips apply to recall situations. Is a medical certificate required after sick leave? Yes. Following sick leave, your company may require a medical certificate confirming your fitness to resume work. This is standard practice for absences exceeding 3 consecutive days or for patterns of frequent short-term absences. The certificate serves to verify your readiness to return to work duties. Who is authorized to issue medical certificates? Your company may designate specific healthcare providers authorized to issue valid medical certificates. Some organizations maintain a panel of approved practitioners or exclusively accept certificates from government healthcare facilities. Consult your company's policy to ensure you obtain certification from an authorized medical professional. What are the consequences of unauthorized leave extensions? Extending leave without prior authorization may trigger disciplinary proceedings. Such absences may be classified as unauthorized and result in salary deductions for the extended period. In severe cases, this could negatively impact your performance evaluation or lead to formal disciplinary warnings. Can I be required to work during sick leave? Generally, companies should not expect work contributions during sick leave. This leave category is specifically designated for recovery, and work activities may impede the healing process. However, in exceptional circumstances, minimal contact may be made for critical information that only you possess. What if illness occurs during another leave type? If you become ill during annual or other scheduled leave, many companies permit the conversion of that portion to sick leave, thereby preserving your original leave balance. This typically requires proper medical documentation and prompt notification to your HR department before your scheduled return date. Common questions about earned leave. Earned leave accrues at a rate of 1 month per 11 months worked, with a maximum accumulation of 90 days. Employees receive full pay during this leave, and unused leave can be encashed under specific circumstances. How much earned leave can I get? You accrue 1 month of earned leave with full pay for every 11 months of service. Accumulation is capped at 90 days to ensure equitable distribution of leave benefits across the organization. What counts as work time? Work time encompasses regular work days, weekly rest days, holidays, casual leave, and quarantine leave. Periods spent in official training programs and authorized work travel also contribute toward your earned leave calculation. How much pay will I get during leave? You will receive compensation equivalent to your average monthly pay calculated from the past 12 months preceding your leave. This includes your basic salary and regular allowances but excludes one-time bonuses or special payments. Can I get money instead of taking leave? Upon resignation or retirement, you can encash up to 30 days of unused leave. Special provisions apply if your leave was previously denied or in case of death during service. Encashment is calculated at your current pay rate and typically processed with your final settlement. Can I take earned leave in parts? Yes. You may divide your earned leave into smaller segments rather than using it all at once. Generally, each leave request should be for a minimum of 3 consecutive days, unless management approves special circumstances. How do I apply for earned leave? Submit a leave application to your department head at least 15 days before your intended leave commencement date. For emergencies, exceptions to this advance notice requirement may be granted, though appropriate documentation might be necessary. What if my leave request is denied? If your leave is denied due to operational requirements, your unused leave can exceed the standard 90-day accumulation limit. In certain situations, you may qualify for encashment of the denied leave days at the conclusion of the financial year. Employees are entitled to various leave types including medical leave, 1 month at half pay per 18 months worked, casual leave, 15 days annually, quarantine leave, and study leave. Options exist to combine different leave types or take unpaid leave when necessary. Understanding your leave entitlements helps you balance work responsibilities with personal health and development needs. Common questions about medical and special leave. How much medical leave can I get? For every 18 months of service, you earn 1 month of medical leave at half pay. You can accumulate up to 90 days of medical leave. This system ensures adequate coverage during illness or recovery periods and is based on your continuous service with the organization. Can I combine medical leave with earned leave? Yes. You may take medical leave and earned leave consecutively for up to 120 days. This option provides flexibility for managing longer-term health issues. Your department head must approve combined leave applications in advance whenever possible. Can I get full pay during medical leave? You can convert half-pay medical leave to full-pay leave at a 2-to-1 ratio. For example, 30 days of half-pay leave converts to 15 days of full-pay leave. This option helps maintain financial stability during shorter recovery periods. What is quarantine leave? Quarantine leave provides up to 21 days with full pay if you have an infectious disease, extendable to 30 days in special cases. This leave applies when your presence at work would risk others' health. You must submit a certificate from an authorized medical practitioner confirming the infectious nature of your illness. What if I have used all my leave? You may request extraordinary leave, unpaid, for up to 90 days per calendar year or leave not due, advanced against future medical leave, with your supervisor's approval. Leave not due requires a medical certificate for illnesses exceeding 3 days. Is there leave for education? Study leave is available for educational purposes, with pay determination at your supervisor's discretion. This leave typically supports courses enhancing skills relevant to your current role. Depending on the program's duration and relevance, it may be fully paid, partially paid, or unpaid. You may need to sign a service bond for a specified period. How much casual leave can I take? You are entitled to 15 days of casual leave annually, with a maximum of 5 consecutive days per request. Casual leave cannot be carried forward to the next year. While it requires minimal notice, it should not be used to extend other leaves or holidays without prior approval. How should I apply for medical leave? Submit a leave application to your immediate supervisor promptly. For medical leave exceeding 3 days, include a medical certificate from a registered practitioner. In emergencies, notify your supervisor by phone or email, then formalize your application upon returning to work. Can medical leave be denied? Medical leave supported by a valid medical certificate is rarely denied. However, the organization may request a second medical opinion in certain circumstances. If discrepancies arise, a third opinion may be sought from a mutually agreed practitioner. Common questions about rest days and holidays. Weekly rest days are displayed on official notice boards, with compensatory holidays limited to 2 per week. Any changes to holiday schedules require 3 days advance notice, and all accrued compensatory holidays must be utilized prior to termination of employment. How will I know my weekly rest day? Your designated rest day will be clearly indicated on an official notice. This schedule will be prominently displayed on the notice board outside the office for easy reference. for organizations with varied rest day schedules. The notice will specify each employee's allocated rest day. How are compensatory holidays administered? You are entitled to no more than 2 compensatory holidays within a single week, with exceptions for continuous work situations. Management will publish the upcoming month's compensatory holiday schedule before the end of the current month. Any schedule modifications will be communicated at least 3 days in advance. What happens to my compensatory holidays upon termination? Any accumulated compensatory holidays must be taken before your final day of employment. These entitled days are not calculated as part of your notice period when determining your official termination date. Who determines the weekly rest day? The organization has the authority to designate your weekly rest day. This information must be transparently displayed on the official notice board for all employees to access. Can my compensatory holidays be rescheduled? While adjustments to compensatory holidays are permissible, the organization is required to provide at least 3 days prior notification of any changes to your scheduled time off. What if I'm required to work on my rest day? If work duties necessitate your presence on your designated rest day, you are entitled to a compensatory holiday that must be scheduled within 3 days before or after the original rest day. Additionally, you will receive compensation at twice your standard rate for hours worked on that day. Are festival holidays distinct from weekly rest days? Yes. Festival holidays constitute a separate category from weekly rest days. You are entitled to all officially declared festival holidays with full compensation. Should you work on a festival holiday, you will receive an additional day's wages plus a compensatory holiday. Can I opt to work on holidays for additional compensation rather than taking time off? This option depends on organizational policy. Some employers permit staff to work on holidays in exchange for supplementary wages instead of compensatory leave, provided this arrangement is mutually agreed upon and properly documented. What occurs when a weekly rest day coincides with a public holiday? If your scheduled weekly rest day falls on a public holiday, your entitlement to that holiday remains intact. In most instances, the organization will allocate an alternative rest day within the same week. How are holiday entitlements calculated for part-time employees? Part-time employees receive rest days and holidays proportionate to their contracted working hours. The specific calculation methodology varies according to organizational policy, though the principle of proportional entitlement is consistently applied. Common questions about overtime pay. Overtime work is compensated at double the normal rate, with limitations on total hours and special counting rules. For monthly workers, daily wages are calculated as 1/26th of monthly pay. How much will I get paid for overtime work? You will receive double your normal pay rate for any work beyond 8 hours in a day or 48 hours in a week. This additional compensation is included with your regular pay. For example, if your hourly rate is $10, you'll receive $20 per hour for overtime work, regardless of your position or department. How is overtime time counted? Overtime periods of 15 to 30 minutes are rounded up and paid as 30 minutes. Work exceeding 30 minutes is paid as a full hour. This rounding system ensures fair compensation for partial hours. All overtime must be recorded in the company's time tracking system and approved by your supervisor. How is daily pay calculated for monthly workers? For monthly paid employees, your daily wage equals 1/26th of your monthly salary. This calculation applies when determining overtime rates and other benefits. For instance, with a monthly salary of $2,600, your daily rate would be $100, making your hourly rate $12.50 for an 8-hour workday. Is there a limit on overtime hours? Yes. Overtime is capped at 125 hours per 3-month period. This limit protects workers from excessive workloads and ensures adequate rest. Managers monitor overtime hours to prevent exceeding this threshold. As you approach this limit, your supervisor will adjust schedules accordingly. When can I work more than 12 hours in a day? Extended workdays beyond 12 hours are permitted only in exceptional circumstances, urgent repairs, preparatory work, emergency situations, loading/unloading operations, or work deemed critical to national interest. Such exceptions require senior management approval and proper documentation, with appropriate rest periods provided afterward. How do holidays and rest days affect overtime calculations? Work performed on designated holidays or weekly rest days entitles you to double wages. Overtime during these days is calculated at twice the doubled rate, effectively providing 4 times your normal wage for those hours. This premium rate acknowledges the sacrifice of working during designated rest periods. How is overtime pay recorded and when is it paid? All overtime hours must be logged in the company's time management system and verified by your supervisor. Overtime compensation appears in your regular paycheck for the applicable pay period, with overtime hours and amounts clearly itemized on your pay statement. Common questions about record keeping. Employers must maintain accessible work schedules, comprehensive electronic employee records, and clearly written documentation that must be retained for 1 year and available for inspection upon request. Proper record keeping is essential for legal compliance, helps resolve workplace disputes, and ensures transparency in employer-employee relationships. Where should I put the work schedule notice? Display the work schedule notice on a prominently located board visible to all employees. Place this board in a central location that employees regularly pass, such as near the entrance, time clock, or break room. Maintain a copy of Form 7 in your records and submit one to the inspector within 7 days of posting. Update the notice promptly whenever schedule changes occur. What records do I need to keep about workers? Maintain comprehensive electronic records documenting workers' personal information, compensation, overtime hours, fines, and payroll deductions. These should include employment terms, attendance records, leave balances, performance evaluations, and disciplinary actions. Store these records securely at your office or workplace, balancing employee privacy with accessibility for authorized personnel. How should I write these records? For handwritten records, use permanent ink that won't fade over time. Ensure all entries are legible and written in English and Hindi or the predominant local language. Avoid ambiguous abbreviations. Date and sign all entries with the responsible manager's signature. Retain all records for at least 1 year after the final entry, though keeping important employment documentation for longer periods is recommended. When must I show these records? Present records upon request from an inspector or authorized government official. Be prepared to produce all requested documentation within 24 hours of receiving the request. Electronic submission is acceptable if approved by the inspector. Failure to comply with record requests may result in penalties or legal consequences for your business. What happens if my records are incomplete or missing? Incomplete or missing records may lead to fines, penalties, or legal complications. If records are accidentally lost or damaged, immediately document the circumstances and notify the inspector. For electronic systems, implement regular backups and disaster recovery protocols to safeguard against data loss and minimize operational disruption. Can I use digital record-keeping systems? Digital record-keeping systems are not only acceptable but increasingly preferred. Ensure your digital infrastructure is secure, regularly backed up, and compliant with relevant data protection regulations. Your system must facilitate easy retrieval, printing, and sharing of records when requested by inspectors. Maintain documentation of security measures and backup procedures to demonstrate compliance. Common questions about notice boards and annual returns. Display essential workplace information on multilingual notice boards. Submit annual reports by the 1st of February, and maintain comprehensive accident and leave records to comply with labor regulations and ensure workplace transparency. What must I show on my workplace notice board? You must display full business name and registered address. Work hours with break periods clearly specified. Days and times of wage payments. Records of accidents from the past 5 years with outcomes. Name and contact information of your local inspector. Dates of delayed wage payments with explanation. This information promotes transparency and helps workers understand their rights and workplace policies. What languages must I use on my notice board? Display notices in English, Hindi, and the predominant local language understood by your workforce. This ensures all employees can access and understand important workplace information regardless of their linguistic background. Consider writing translations in other languages spoken by significant portions of your workforce to maximize comprehension. When must I send in my yearly report? Submit your yearly report by the 1st of February following the end of each calendar year. The report must cover all activities from the 1st of January to the 31st of December of the previous year. Begin preparation by mid-January to ensure timely submission and avoid penalties for late filing. This allows sufficient time to address any data collection issues that may arise.
Who gets copies of my yearly report? 2 printed copies to your local inspector. 1 electronic copy to the Director General, Labor Bureau. Ensure all copies contain identical information with proper authorization signatures. Submit the electronic copy in PDF format with all required attachments. Retain submission receipts as proof of compliance for your records. What other records must I keep? You must maintain accident records in Form X, workers' leave documentation in Form XI, safety training session logs, equipment maintenance records, health checkup documentation, safety committee meeting minutes. Organize these records chronologically for easy retrieval during inspections and retain them for the duration specified by labor regulations. Regular review of these records can help identify safety trends and improvement opportunities. Common questions about inspector powers. Essential insights into inspector authority under workplace safety regulations. Inspectors can collect and divide material samples into 3 equal portions when they suspect safety violations. These samples undergo secure sealing, testing in accredited government laboratories, and serve as admissible evidence in legal proceedings. Strict protocols safeguard sample integrity throughout the entire process. What can inspectors collect from workplaces? Inspectors may collect samples of materials, substances, and products from workplaces when they suspect potential health hazards or safety violations. Their authority extends to chemicals, raw materials, finished products, and any substances that might cause occupational risks. Each collection requires thorough documentation and receipts for all samples obtained. How are samples divided? Samples undergo division into 3 identical portions following precise protocols. Each portion receives proper sealing in appropriate containers and clear identification markings, while a workplace representative witnesses the entire procedure. Representatives may add their own seal to the containers and verify all identification details, ensuring transparency and maintaining a secure chain of custody. Where do these sample parts go? 1 portion transfers immediately to the workplace occupier as their reference sample. 1 portion goes to a government-approved laboratory for thorough analysis. The final portion remains with the inspector in controlled storage as a control sample for potential verification or court evidence. All transfers require proper documentation with verification signatures. How are test results used? Reports and certificates from government laboratories or approved testing facilities serve as official evidence in legal proceedings. Courts accept these documents as prima facie evidence for presumed valid unless proven otherwise. Employers retain the right to challenge findings by requesting independent testing of their sample portion within designated timeframes. What powers do inspectors have to enter and examine workplaces? Inspectors possess authority to enter any workplace at reasonable times without prior notification. They may examine facilities, equipment materials, and documentation related to workplace safety. They can conduct private worker interviews, capture photographs, create recordings, and require workplace assistance during inspections. They must present official identification credentials before beginning any inspection activities. What happens if someone obstructs an inspector's work? Obstructing an inspector constitutes a punishable offense. This includes denying entry, withholding required documents, concealing evidence, intimidating witnesses, or providing false information. Consequences range from substantial fines to imprisonment based on obstruction severity. All workplace participants bear a legal obligation to cooperate fully with inspectors. Frequently asked questions. Inspectors issue formal notices for workplace violations, conduct systematic follow-up investigations, and maintain comprehensive documentation of their findings. Medical officers must be qualified physicians who monitor workers in hazardous occupations and conduct thorough health assessments. What can inspectors do after checking a workplace? Following a workplace inspection, inspectors have the authority to issue formal notices when health or safety regulations are violated. They utilize Form 12 to officially document non-compliance issues that require remediation. These notices typically include specific compliance deadlines, detailed corrective action requirements, and potential penalties for continued non-compliance. For severe violations that present immediate danger to worker safety, inspectors can mandate emergency interventions and temporary work stoppages. Do inspectors follow up on problems they found before? Yes. Inspectors conduct scheduled follow-up visits to verify that previously identified violations have been properly addressed. During these re-inspections, they meticulously document both the status of prior issues and any new compliance concerns discovered. This comprehensive documentation creates a detailed compliance history for each workplace, establishing patterns of behavior that may influence regulatory decisions, enforcement actions, and potential penalties in future proceedings. Who can be a medical officer? A medical officer must be a licensed physician with appropriate professional qualifications. They must maintain active registration with both the Indian Medical Register and their respective state medical register. They should possess specialized expertise in occupational medicine, including comprehensive knowledge of workplace hazards and their associated health effects. Many medical officers hold advanced certifications in industrial medicine or public health to enhance their effectiveness in this specialized role. What jobs do medical officers do? Medical officers conduct regular health monitoring for employees in high-risk occupations. They diagnose, treat, and document work-related illnesses and injuries. They evaluate young workers to ensure they meet minimum age requirements and possess the physical capacity to safely perform assigned duties. Their comprehensive responsibilities include conducting periodic health assessments, maintaining confidential medical records, advising management on workplace health improvements, participating in safety committee initiatives, and establishing emergency medical response protocols for workplace accidents or hazardous material exposures. FAQs about women's work rules. Women can work night shifts with proper consent and support, must have adequate workplace facilities, can work in underground mines with specific safeguards, and are protected by comprehensive anti-harassment legislation. These regulations ensure safety, equality, and dignified working conditions for women across all sectors. Can women work at night? Yes, women can work at night, before 6 a.m. or after 7 p.m. provided these conditions are met. The woman provides explicit written consent for night work. All maternity benefits, under the Maternity Benefit Act, are guaranteed. The employer provides free, safe, and reliable transportation between work and home. Adequate security personnel are present during all night shifts. The workplace maintains comprehensive records of women working night shifts. Appropriate rest periods and breaks are scheduled throughout night shifts. Employers must consistently maintain these provisions for all night shifts involving women employees without exception. What facilities must be at the workplace? Employers must provide essential facilities to ensure women's well-being and safety. Adequate lighting throughout all work areas, corridors, elevators, and restrooms. Hygienic, well-ventilated toilets with regular maintenance schedules. Accessible safe drinking water stations in proximity to work areas. Separate changing rooms and washrooms as required by regulations. Proper ventilation and temperature control throughout the workplace. Designated rest areas specifically for women employees. Fully equipped first aid kits and accessible medical facilities. Safe working environment with clearly marked emergency exits. These facilities must undergo regular inspections to verify compliance with quality and safety standards. Can women work in underground mines? Yes, women can work in underground mines under these specific conditions. A minimum of 3 women must work together in the same location at all times. Women are permitted in technical, supervisory, and managerial roles in any underground mine. Specialized safety training must be completed before commencing underground work. Women-specific protective equipment must be provided and properly fitted. Mandatory regular medical examinations for women working underground. Clearly defined emergency response protocols with regular practice drills. These regulations aim to balance workplace safety with equal employment opportunities for women. How are women protected from harassment? All workplaces must implement the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act, 2013, which mandates Internal Complaints Committee ICC establishment in workplaces with 10+ employees. Structured procedures for complaint filing and resolution. Prompt and thorough investigation of all reported incidents. Absolute confidentiality regarding complainant identity and details. Safeguards against any form of retaliation for filing complaints. Ongoing awareness programs and educational workshops about workplace harassment. Prominent display of sexual harassment consequences in common areas. Mandatory submission of annual harassment case reports to government authorities. Non-compliance with these requirements subjects employers to substantial penalties and legal consequences. Frequently asked questions. Contract labor. Contractors must satisfy strict eligibility criteria, deliver comprehensive worker benefits, and ensure accurate and timely payments. Principal employers remain responsible for providing essential workplace facilities. Non-compliance with wage regulations triggers immediate intervention by labor authorities and significant financial penalties. Who can't become a contractor? You are ineligible to become a contractor if you face financial insolvency or inability to meet debt obligations, including pending bankruptcy proceedings or court-declared insolvency. You were convicted of a criminal offense within the past 2 years, resulting in imprisonment exceeding 3 months. You have previously violated any provisions of labor legislation. You lack sufficient financial resources to fulfill payment obligations to workers. You fail to secure necessary certifications from relevant regulatory authorities. Qualified contractors must maintain comprehensive documentation, including valid registration certificates, detailed worker records, and evidence of compliance with all applicable labor laws. What must contractors do for workers? Contractors must adhere to working hour regulations, maximum 8-hour workday, with overtime compensated at twice the standard rate. Disperse wages in accordance with the 2019 Wage Code promptly, without unauthorized deductions. Provide all statutory benefits, including paid leave, holidays, and Social Security entitlements. Issue standardized identity cards to all workers. Maintain precise attendance and wage records. Implement appropriate health and safety protocols at the workplace. Register workers with designated authorities for applicable Social Security schemes. Provide adequate training for specialized tasks. Contractors bear responsibility for addressing worker grievances promptly and effectively. What must the principal employer provide? When contract workers operate at the principal employer's premises, the principal employer must furnish hygienic and accessible sanitation facilities, gender-segregated, potable drinking water at strategic locations throughout the workplace, adequate bathing and changing facilities with appropriate privacy, first aid stations with essential medical supplies in each work area, canteen facilities offering nutritious meals at reasonable prices when employing workers above the statutory threshold, child care facilities, creches, when workforce exceeds 50 employees, sufficient lighting and ventilation throughout work areas, fire safety equipment and clearly marked emergency exits, designated rest areas for workers during extended shifts. The principal employer must conduct regular inspections to ensure these facilities meet prescribed quality standards. What happens if contractors don't pay workers? If a contractor fails to disperse minimum wages, the Chief Labor Commissioner initiates enforcement proceedings to secure worker compensation. Payments are drawn from the contractor's mandatory security deposit. Bank guarantees may be invoked to address any payment deficits. The contractor faces potential license suspension or revocation. Legal sanctions, including monetary penalties and possible incarceration, may be imposed. The principal employer may become jointly liable for wage obligations. Workers can submit complaints through designated grievance portals. Labor departments conduct systematic inspections to prevent such violations, and workers can report payment irregularities through multiple channels, including toll-free helplines. Common questions about contractor licensing. Contractor licenses require specific application procedures, have jurisdiction-based validity periods, cannot be transferred, and incur fees based on workforce size. Understanding these requirements is essential for compliance with labor regulations. How do I apply for a contractor license? Complete Form 13 through the official Shram Suvidha portal. Provide comprehensive details about your business entity, projected workforce size, and specific scope of contracted work. Submit all required supporting documentation, including valid identity proof, business registration certificates, and proof of address. What if I operate in multiple states? Submit your application directly to the central government authority. The central authority will coordinate with all relevant state departments where you intend to operate. This centralized approach eliminates the need for multiple applications and creates a streamlined approval process for cross-state operations. What is the validity period of my license? Multi-state licenses issued by the central authority remain valid for 5 years. Single-state licenses follow state-specific regulations, with validity periods typically ranging from 1 to 3 years. Submit renewal applications at least 30 days before expiration to ensure business continuity and avoid operational disruptions. Can I transfer my license to another entity? No. Licenses are non-transferable and issued specifically to the applicant based on their qualifications and business particulars. The license validates your specific capability to fulfill contractor obligations in compliance with labor laws. Any attempt to share, transfer, or sell your license constitutes a violation of licensing terms. What are the license fee requirements? Fees are mandatory and structured according to your total workforce size. The fee schedule follows a tiered structure that increases proportionally with larger workforce numbers. These fees support the administrative framework necessary for effective regulation and monitoring of contractor operations. Refer to the official fee schedule to determine your specific payment obligation based on current workforce projections. What is required if my business details change? Notify the licensing authority in writing within 30 days of any significant business changes, including address modifications, operational expansions, or substantial workforce increases. Submit appropriate documentation validating the reported changes. Failure to update your information may result in penalties, fines, or potential license invalidation. Will my operations be subject to inspection? Yes. Labor authorities conduct scheduled and surprise inspections to verify compliance with labor laws and license conditions. Inspectors will examine worker documentation, wage payment records, workplace safety measures, and overall working conditions. Maintaining comprehensive records and strict adherence to regulatory requirements will facilitate successful inspection outcomes. Common questions about security deposit and license fees. Security deposits are Rs 1,000 per worker. License fees range from Rs 0 for under 50 workers to Rs 40,000 for 20,000 plus workers, with graduated fee tiers based on workforce size. Understanding these financial obligations is essential for contractor license compliance. How much security deposit must I pay? The required security deposit is Rs 1,000 per worker. This deposit serves as financial assurance that you will comply with all labor regulations. You can reclaim this deposit upon work completion and verification of regulatory compliance. All deposits must be submitted through the Shram Suvidha portal via online transaction. Can I use my old security deposit for a new license? Yes. If your previous license has expired, you may request to transfer that deposit to your new license application. Submit Form 14 along with documentation of your previous license and deposit payment. Note that transfer requests must be filed within 90 days of your previous license expiration. Do I need to pay a fee if I hire fewer than 50 workers? No. Contractors employing up to 49 workers are exempt from license fees. However, you still must register and obtain a contractor license despite this fee exemption. All standard documentation requirements remain applicable regardless of fee status. How much is the license fee if I hire 200 workers? For 300 workers, the license fee is Rs 2,000. This is a one-time payment for your initial license period. Remember that this fee is separate from and additional to the mandatory security deposit of Rs 1,000 per worker. When do I need to pay the license fees and security deposit? Both the license fee and security deposit must be paid at the time of application submission. Incomplete payments will result in your application being classified as pending until all financial requirements are fulfilled. What is the highest license fee I might need to pay? The maximum license fee is Rs 40,000, applicable when employing 20,001 or more workers. This fee remains fixed regardless of how many additional workers you employ beyond this threshold. Organizations in this category should budget accordingly. Is the security deposit refundable if I cancel my contract? Yes, security deposits are refundable upon completion of all contractual obligations and verification of labor law compliance. To claim your refund, submit Form 15 within 30 days of contract completion, along with supporting documentation proving compliance and work completion. What is the fee structure based on number of workers? The fee structure is as follows. Rs 1,000 for 100 workers, Rs 2,000 for 300, Rs 3,000 for 500, Rs 5,000 for 501 to 1,000, Rs 10,000 for 1,001 to 5,000, Rs 20,000 for 5,001 to 10,000, Rs 30,000 for 10,001 to 20,000, and Rs 40,000 for more than 20,000 workers. These fees are established by the central government and are subject to periodic revision. So always verify current rates on the official website. License renewal and refund. FAQs. Renew your contractor license 30 to 90 days before expiration. Pay standard fees, with 25% late penalty if applicable, and expect processing within 30 days. For security deposit refunds, submit your application online with all required documentation to receive payment within 30 days of approval. When should I apply for license renewal? Submit your application through the Shram Suvidha portal 30 to 90 days before your license expires. Applications submitted more than 90 days in advance will not be accepted by the system. Applying less than 30 days before expiration may result in processing delays and potential license lapse. How much does renewal cost? Renewal fees match the initial licensing fee structure based on workforce size. Fees range from no cost for fewer than 50 workers to Rs. 40,000 for more than 20,000 workers. Applications submitted after expiration incur a 25% late penalty on the standard fee amount. How long will renewal take? The licensing authority must process complete applications within 30 days. You will receive automated email notifications at each processing stage. If you don't receive any response after 30 days, contact your regional labor office with your application reference number for status verification. How do I get my security deposit back if I don't renew? Submit a refund application through the online portal with copies of your expired license, work completion certificate, and current bank details. You must also provide a legally signed affidavit confirming all worker payments and statutory obligations have been fulfilled. Submit this application within 60 days of license expiration or contract completion. When will I get my deposit refund? Compliant contractors receive refunds within 30 days of application approval. Any outstanding penalties or worker claims will be deducted from the refund amount. Funds will be transferred electronically to your registered bank account, and you'll receive confirmation via email once the transaction is processed. What happens if I miss the renewal deadline? Missing the renewal deadline results in license expiration, requiring a new license application rather than a renewal. This involves paying the standard fee plus a 25% penalty. Operating with an expired license may result in additional penalties and legal complications under labor law provisions. Can I update my worker count during renewal? Yes, you can update your worker count during renewal. Your fee will be adjusted according to the appropriate bracket for your updated workforce size. Significant changes in worker numbers may require supporting documentation to verify the adjustment. Ensure accurate reporting to maintain compliance with labor regulations. What documents are required for license renewal? Required renewal documentation includes current license copy, labor law compliance declaration, updated worker details, security deposit payment proof, and current banking information. Any changes to business name, location, or ownership structure require additional verification documents, such as registration certificates and legal declarations of change. Common questions about contractor rules. Contractors must adhere to regulations on fair wages, equal treatment, social security benefits, timely reporting, and electronic payment methods. These rules protect workers and ensure compliance with labor laws. How much should contractors pay workers? Contractors must pay at least the minimum wage rates established by the Code on Wages, 2019, or higher if contractually agreed. Rates vary by region, skill level, and industry. Detailed wage records must be maintained for 3 years for inspection purposes. Do contract workers get the same pay as regular workers? Yes. Contract workers performing the same duties as regular employees must receive equal wages, holidays, work hours, and benefits. This equality extends to overtime rates, leave entitlements, medical benefits, and safety provisions. Employment status-based discrimination is prohibited. What Social Security must contractors provide? Contractors must enroll all eligible workers in EPFO and ESIC programs within 30 days of employment and make monthly contributions. They must also provide accident insurance and maintain proper documentation of all enrollments and contributions. What must contractors tell the authorities? Contractors must report any changes in workforce size or working conditions. Within 15 days of receiving a work order, they must submit details about the employer, work location, start date, worker count, and project duration. Quarterly returns regarding worker turnover, accidents, wage disbursements, and welfare measures are also required. When must workers be paid? Payment periods cannot exceed 1 month, with wages due by the 7th day after the period ends. All payments must be made electronically through bank transfers. Contractors must provide detailed pay slips showing wages, allowances, deductions, and net pay. Cash payments are prohibited, except with prior approval in exceptional circumstances. What records must contractors maintain? Contractors must keep comprehensive records, including worker details, attendance, wages, overtime, leave, and safety training logs. These records must be preserved for at least 3 years and be readily accessible for inspection. Digital record keeping is encouraged, but must follow specified formats. What are the working hour regulations? Workers should not exceed 8 hours daily, or 48 hours weekly under normal conditions. Overtime must be compensated at double the standard rate, and cannot exceed 125 hours quarterly. Workers must receive 1 weekly day off, and appropriate breaks during shifts. Exceptions require special authorization. What welfare facilities must contractors provide? All work sites must have adequate drinking water, sanitation facilities, first aid kits, and rest areas. Sites with more than 50 workers require canteen facilities, while those with over 100 workers must provide temporary accommodations for workers from different regions. Gender-appropriate facilities are mandatory when both men and women are employed. Common questions about licenses and certificates. Clear guidance on contractor licensing requirements and worker documentation. Contractors may face license suspension for regulatory violations, but have appeal rights and remediation options. Workers are entitled to request detailed experience certificates that document their employment history and acquired skills. When can a contractor's license be revoked? Licenses may be revoked if a contractor obtained it through misrepresentation or fails to comply with regulations. The authority issues a 15-day notice requesting explanation before taking action. Significant grounds for revocation include persistent safety violations, improper worker compensation, or operating without mandatory insurance coverage. Can a contractor reinstate a revoked license? Yes. Contractors who address all violations within the specified timeframe can apply for reinstatement. Failure to remediate issues may result in permanent revocation. Reinstatement applications must include comprehensive documentation verifying all corrections and payment of any outstanding penalties. What appeal options exist for license revocation decisions? Contractors may appeal to the Chief Labor Commissioner, Central, for review of the decision. This appeal must be submitted within 30 days of receiving the revocation notice. The appeal should include all relevant supporting documentation and evidence to substantiate the contractor's position during the review process. Are workers entitled to documentation of their employment? Yes. Workers have the legal right to request experience certificates from contractors. These official documents detail employment duration, job responsibilities, and skills developed. Contractors must provide these certificates upon request, and workers should maintain them as essential verification of their professional history. What details must experience certificates contain? Experience certificates issued in Form 15 must specify the employment period, work functions performed, and competencies developed in various areas. The document must include the contractor's registration information, project details, and may incorporate performance evaluations when available. What is the duration of contractor license validity? Contractor licenses generally remain valid for 5 years from issuance. Renewal applications must be submitted at least 30 days before expiration. Operating with an expired license can trigger financial penalties and immediate suspension of operations. Are specialized licenses required for different work categories? Yes. Contractors must obtain specific licenses aligned with their operational focus, such as electrical work, plumbing, construction, or hazardous materials handling. Each specialty has unique qualification requirements and compliance criteria that must be satisfied before licensing approval. How do experience certificates benefit workers' career advancement? Experience certificates serve as valuable professional credentials that verify a worker's expertise and employment background. These documents enhance job applications, support negotiations for higher compensation, demonstrate qualifications for specialized positions, and establish professional credibility with prospective employers. Many advanced positions specifically require documented evidence of relevant experience. Common questions about interstate migrant workers. Interstate migrant workers are entitled to transportation allowances, dedicated government support services, and comprehensive welfare programs. These benefits are designed to safeguard workers who relocate across state boundaries for employment opportunities and ensure equitable treatment regardless of their workplace location. What travel allowances do migrant workers receive? Employers must provide round-trip train tickets, minimum second-class sleeper, or equivalent bus fare. This allowance facilitates worker travel between their employment location and home state. The benefit encompasses both transportation costs and a daily subsistence allowance during the journey period to cover meals and essential needs. Who qualifies for travel allowances? Workers who have completed at least 180 days of service within the previous 12 months. This benefit can be claimed once annually. Eligibility is limited to workers who were specifically recruited for employment in another state and are officially registered under the Interstate Migrant Worker Regulatory Framework. Is there a dedicated support system for migrant workers? Yes. The Ministry of Labor maintains a toll-free helpline service. Workers can contact this service for information, guidance, or to file complaints. The helpline offers support in multiple regional languages to ensure accessibility for workers from all states. Specialized operators provide information regarding legal rights, available benefits, and connections to local support resources. How does the government ensure migrant worker welfare? The government conducts research on occupational safety and health standards specific to migrant workers. They collaborate with state authorities and subject matter experts to enhance worker protection measures. Initiatives include establishing equitable wage standards, workplace condition monitoring, and developing targeted social security programs that address the unique vulnerabilities of the migrant workforce. What accommodation benefits are provided to migrant workers? Employers are legally required to arrange appropriate housing for interstate migrant workers. Such accommodations must comply with fundamental safety and sanitation requirements as outlined in labor regulations. In certain circumstances, a housing stipend may be offered as an alternative when direct accommodation arrangements are not feasible. What healthcare provisions exist for migrant workers? Interstate migrant workers are entitled to comprehensive healthcare benefits through various government initiatives. Employers must provide on-site first aid facilities and schedule periodic medical examinations. For work-related injuries or illnesses, workers are guaranteed medical care and appropriate compensation according to established guidelines. How can migrant workers maintain access to home state benefits while employed elsewhere? The government has implemented cross-state benefit portability mechanisms for registered migrant workers. This system enables continuous access to food security programs, healthcare services, and social welfare benefits regardless of current work location. Workers should regularly update their information in the centralized migrant worker database to ensure seamless benefit access. Common questions about audiovisual worker agreements. Audiovisual worker agreements must use government-approved Form 16, detailing work duration, compensation, and conditions. These legally binding documents protect both workers and producers in the entertainment industry, ensuring fair treatment and clear expectations. Disputes are resolved according to the Industrial Relations Code of 2020, which provides a structured framework for addressing workplace conflicts. What form should audiovisual worker agreements use? All agreements must utilize Form 16 as mandated by law and receive central government approval before implementation. This standardized format ensures comprehensive protection of rights and inclusion of all essential elements. Production companies must retain these agreements for at least 3 years after project completion for possible regulatory inspection. What does the agreement cover? The agreement comprehensively outlines contract duration, reporting times, shooting schedules, base compensation, overtime rates, advance payment terms, and working conditions including safety provisions, break periods, and on-set facilities. Additionally, it addresses intellectual property rights, credit acknowledgement, and confidentiality requirements binding both parties. How are disputes between workers and producers resolved? Disputes follow resolution procedures established in the Industrial Relations Code of 2020. Which grants audiovisual workers the same protections as formal sector employees. The process typically begins with internal grievance procedures, followed by formal mediation when necessary. Both parties receive equal opportunity to present their case, with emphasis on reaching mutually acceptable solutions while preserving professional relationships. Who can provide assistance with disputes? Conciliation officers or specialized tribunals can mediate conflicts between workers and producers. Workers may also seek support from union representatives or industry associations that specialize in entertainment sector labor disputes. For payment-related issues, the Labor Commissioner's Office can intervene to ensure proper compensation.